Good evening. This is the 37th time I have spoken to you from this office. I have always tried to do what was best for the nation. I have felt it was my duty to persevere, to make every possible effort to complete the term of office. I would have preferred to carry through to the finish, whatever the personal agony it would have involved. I shall resign the presidency effective at noon tomorrow. May God's grace be with you in all the days ahead.
Good afternoon and welcome to the Macomb Center for the Performing Arts. And on behalf of the Macomb Bar, I wish to welcome you as well. We're glad to have you at this event. It's been a few years since we've been able to do a mock trial, so we're very excited about today's event. This event is also being recorded by Sterling Heights Cable TV, and we thank them for doing that for us. I'd like to remind everybody at this point, if you have a cell phone or watch alarm, any electronic devices, please be sure they're silent for the duration of the trial. I'm sure you don't want to be in contempt of court. This historical mock trial asks the question, was President Gerald Ford justified in pardoning Richard Nixon for his participation in the events surrounding and following the Watergate and alleged cover-up? Arguing that Ford should be pardoned is attorney Chris Nesi. Arguing that Ford was justified is Professor Robert Sedler. The witnesses include attorney and state bar president Dana Warnes, playing then House member from Michigan Martha Griffiths, attorney Joe Kosmala, Judge Michael Warren as Richard Nixon, columnist Jack Lesenberry, who once interviewed Gerald Ford about this topic, will play Gerald Ford, and Judge John Schmira. Serving as judge will be Rachel Rancillo. The court officer is Bill Barnwell, who will call the court to order and lead us in the Pledge of Allegiance along with the judge. At the conclusion of the trial, please fill out the verdict form. If you did not get one when you came in, raise your hand at the end and someone will get a verdict form to you. Mr. Barnwell.
All rise. The 99th Circuit Court of the State of Michigan is now in session. The Honorable Rachel Rancillo presiding. Please join us for stating the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. May be seated.
All right. Thank you, Mr. Bailiff. And with that, on that note, we will begin openings. Plaintiff's counsel, if you could begin your opening.
Thank you, Your Honor. There are certain iconic images we associate with the law and the proper administration of justice. The black robe worn by the judge, the gavel used to call order in the court. Some of them have ancient roots in our history, in particular the Roman goddess Justinia. Sure you've all seen Lady Justice, the robed statue of a woman holding scales before her with a blindfold. In Roman times, what that was the measure of facts against an argument. Which side would it tip towards? But the blindfold was intended to keep the trier of fact, the person making the judgment, from being biased by the individuals who were against or opposed the position. In modern days, we call her Lady Justice. It doesn't matter if you're black or white, a woman or a man, or your station in life, gardener, a doctor, or a president. Lady Justice doesn't know who you are. She just knows the facts. On June 17, 1972, there was a break-in at the offices of the Democratic National Committee, and no one disputes that fact. No one disputes the fact that the people responsible for it were both staff members on Mr. Nixon's staff as well as those hired for the specific purpose of obtaining information illegally and wiretapping the office of a political party dedicated to the art of democracy that we all practice. There's no argument. What there is an argument about is who was responsible for it and how culpable our then sitting president was for the actions that took place and how culpable he was for an attempt to conceal these actions from the people of the United States of America. Our position to you is that excusing that culpability for this president was unjustified, that the act of President Ford, or then President Ford, was not motivated by a desire to shield the public from further harm or hurt feelings. It was instead the act of a political operative who had no other purpose than to preserve his party's power, grip on power in the country. In furtherance of that argument, we're going to introduce to you several witnesses today. The first will be, as we've heard, Martha Griffiths. She is, or was, from 1954 to 74, the representative from the 17th Congressional District in the state of Michigan. And it's important because she understands not only what the transgressions were that gave rise to articles of impeachment being submitted to our legislative body, but also because she was there at the time and understood what was happening while these events were unfolding. We'll also hear from Mr. Joseph Kosmala, who's not only a practicing attorney, but from time to time in his long and storied career has been a representative, an elected representative, particularly in the government of Macomb, where he served as a Macomb County Commissioner. In his private practice, he has sought redress for misuses of power of government officials, whether they be police officers across the spectrum. He understands what the transgressions were, the impact that they can have on people, and perhaps more importantly, the impact that transgressions of those kinds, if they're excused and wiped away, can have on the political and social culture of the country. We hope that you consider these facts not in the light of protecting ourselves from the information that we all rely on to choose our leaders, but consider them as a man who might be a gardener, a man who might be a doctor, or a president. Thank you very much.
All right, thank you. And opening by defense, counsel.
Members of the jury, good afternoon. In the book of Ecclesiastes, it is written, "For everything there is a season and a time for every purpose under heaven, a time to kill and a time to heal, a time to break down and a time to build up." Members of the jury, it is time for this nation to heal. It is a time to build up, and I would add, a time to move on. This nation has been through a terrible time. It has been enmeshed in the Watergate scandal for some 2 years. Yes, there was a break-in in the headquarters of a political party in an effort to influence the presidential election. There was a cover-up of the break-in by the then president, top aides, and other governmental officials. It was a most extreme abuse of power by those who were sworn to uphold the law. And it has left a terrible scar on this nation. But now it is time for this nation to heal and move on from Watergate. Now, this is what President Ford has tried to do in his pardon of former President Nixon. Now, he's been terribly criticized for doing so. You've just heard, oh, he did this only for political purposes. Well, he put his own political career in jeopardy by pardoning Nixon. You, as members of the jury, must decide whether President Ford was justified in taking the action that he did. You alone must decide whether what President Ford did was in the public interest. And that's what I want to emphasize. Was this in the public interest? I respectfully submit to you that it was. Nixon left the office of the presidency, the most important office in our constitutional system, in complete disgrace. This is the first time that this has happened in the nation's long history. And I ask you, what good would it accomplish by prosecuting Nixon as a criminal? Whatever he did, do we really want to see a former president of the United States languishing in prison? Surely no future president, seeing what happened to Nixon, would ever do what Nixon did. There's no need to prosecute Nixon to deter future presidents. Also, Nixon has admitted his guilt in accepting the pardon. Way back in 1915, the Supreme Court stated that a pardon carries an imputation of guilt, and acceptance of the pardon, a confession of guilt. So Nixon stands guilty in the eyes of the American people for a most serious abuse of power, a most serious disregarding of his sacred oath as president. A criminal prosecution will add nothing to Nixon's admission of guilt. You will hear Nixon explain why he did what he did. But more importantly, you will hear him explain why he resigned from the presidency and why he accepted President Ford's pardon. And again, I think you will see that his resignation from the presidency, his acceptance of the pardon, was clearly in the public interest. Now, you're not going to be any more sympathetic to him, and that's not the purpose. But I think you will at least see this as mitigation of the harm that he caused. You will then hear from a long-serving and highly respected judge about the importance of prosecutorial discretion in the American criminal law system. Judge Shamora will explain precisely why, given the situation in America and the world in the summer of 1974, it was clearly in the public interest that Nixon not be prosecuted, that he be permitted to resign from the presidency, getting a pardon, and so avoiding a criminal prosecution. Finally, you'll hear from President Ford himself. He will explain in detail how he arrived at the very difficult decision to permit Nixon to resign in exchange for a presidential pardon. He will tell you the reasons why he believed that pardoning Nixon was in the best interest of the nation, knowing that the decision would be highly unpopular, that he would be accused of doing this for political purposes. You may say that if you were president, you would not have pardoned Nixon, but that's not the issue before you. The issue before you was whether President Ford was justified in making this very difficult decision. I respectfully submit that when you hear all the evidence put before you, you will conclude that President Ford, acting as President of the United States and trying to do what he considered to be in the public interest, was justified in making the decision to pardon Nixon. Thank you, members of the jury.
Thank you, Professor Sedler. And with that, Mr. Nisi, if you could call your first witness.
Your Honor, we would call Martha Griffiths.
All right. Good morning, and you can be seated, or I should say good afternoon. You should be seated.
Good afternoon, Your Honor.
Ma'am, could you please identify yourself for the record?
Yes, Counselor Nisi. My name's Martha Griffiths. I'm from Missouri.
Well, it's quite a pleasure to meet you, ma'am. Now, I understood that you served in the U.S. House of Representatives for a period of time. Is that correct?
I did, Your Honor. Or did, Mr. Nisi. I'm sorry. Yes, sir.
That's just fine. I'll never get to Your Honor, but I'll take it for now.
Okay.
So, during that period of time, did it include the episode or the issues we're discussing today vis-a-vis Mr. Nixon?
Yes, it did.
So you were there and witnessed these things happen.
I did, and my colleagues did, too.
Okay.
John Conyers was there on the House Judiciary Committee, and he voted for the articles.
And so you were really familiar with Mr. Conyers given your representation of the 17th District.
Yes, yes, sir.
Are you familiar with the articles of impeachment as well?
I am, Mr. Nisi.
Okay. Could you tell me how many articles there were, how many separate groups of allegations?
There were 3 articles.
Okay. If you would be so kind as to explain the first article, briefly summarize it. I know we don't have time to read it today, so just briefly summarize it for the jury.
Well, the first article alleged that the president violated his oath of office by basically obstructing justice. He did all sorts of things with people close to him. All his president's men, you know, my daddy always said that girls were smarter than boys, and I think this whole incident proves that. But to get back to your point, the first article alleges that the president obstructed justice. He and his chief of staff and his attorney, they did everything they could to cover up the burglary. It all centers around the cover-up of the burglary.
You know, it's interesting you mentioned your father. Do you think that he was the type of man, if he was alive at the time, who could have readily discerned what was going on with this situation and made that same judgment?
I think so.
Now, could you describe the second article for us?
Yes, Mr. Nisi. Article 2 was essentially an argument that said the president violated his oath by basically he violated his oath because he was using his power to violate people's constitutional rights. He did things to try to, in the cover-up as well, he was looking to embarrass people, to quiet people. He paid people off. He paid the burglars off to be quiet. When the burglars started to confess and talk about what was going on, he used every way he could to try to save himself. So
Is this the article that also creates some reference to the fact that he may have been responsible for planning the whole event?
Yes, sir.
All right. Could you describe the third article for us as well?
Yes, sir. The third article was that the president violated his oath by abusing his power. He failed to, as you know, and we know, we all should know, the House of Representatives is the only entity of our government empowered to impeach somebody. And when the president failed to answer the subpoenas issued by the House of Representatives, he was placing himself in a higher position than the House of Representatives, and he failed to comply with his subpoenas. So he was really, really abusing his office and violating constitutional separation of government.
Now, just for the jury's sake, a subpoena is an official demand. It's like an order. Produce documents or objects for me to review. Is that correct?
Correct.
And particularly, the subpoena issued in this case was for recordings that were made in the Oval Office itself, which evidenced these crimes. Is that right?
Yes, sir.
Okay. Now, there are two other areas of the law I'd like you to review. The first is, you're familiar, I think we all are, from TV shows and everything else, the Fifth Amendment. Is that correct?
Yes, sir.
Could you briefly read that into the record? I know it's a short passage.
Sure. The Fifth Amendment states, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb." And most importantly here, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
And that's the famous, you can't speak against yourself, you can't incriminate yourself. Is that correct?
Correct.
To put it into layman's terms.
Correct.
Okay. And the next passage is, if you could identify it.
It's Article 2, Section 2, C1.3.11, scope of the pardon power. It's Article 2, Section 2, Clause 1 of the Constitution.
Could you read it, please, into the record?
Yes, sir. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion, in writing, of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment.
Now, reprieves and pardons. So this is the constitutional authority Mr. Ford had to pardon Mr. Nixon. Is that correct?
Correct.
What's the last word in that passage?
Except in cases of impeachment.
Except in cases of impeachment.
Correct.
Thank you.
Thank you.
right.
Am I done, Your Honor? On cross-examination, right?
Yes, Professor Sedler will have the opportunity to cross-examine at this point.
Representative Griffith, you voted in favor of the bill of impeachment, is that correct?
My colleagues did, yes, sir.
What is the constitutional purpose of impeachment?
It is to remove a president who's violated his oath and his duties.
Clearly, the purpose, as you point out, of impeachment is to remove a president who has committed a serious breach of official duty or engaged in a serious abuse of power. We agree on that.
Yes, sir.
It's all about removal, isn't it?
Yes, sir.
When former President Nixon resigned, he was removed, correct?
He voluntarily removed him. He didn't let the process work itself out. He didn't. He took it into his own hands.
But he was removed, which means that the constitutional purpose of impeachment was accomplished by his resignation. Isn't that correct?
You could say so, sir, yes.
Now, we agree that a criminal prosecution is separate. I would ask you, as a longtime public servant, with Nixon having resigned in disgrace, how is the public interest advanced by a criminal prosecution of Nixon?
Well, sir, we all believe in our adversarial system, and I think sometimes the truth needs to be told and needs to be heard. And just because someone removes themselves from that process, that doesn't serve the public. We don't know what happened.
Well, do we not know what happened from the hearings before the House Judiciary Committee? All the facts were laid out in that report, were they not?
Well, sir, I think that's a matter of opinion. I would say that many, many facts are laid out there, but whether they're entirely true, we don't know unless the defendant would be put on the stand or have the hearing process work itself out that way.
But how is the public interest served? By raking over all the events of Watergate again. Isn't it time to move on?
Well, sir, I think that Mr. Nixon made his decision for his own reasons and probably in his mind for the best of the country. So I'm going to leave it there if I may.
So you think that it is in the public interest to see Nixon prosecuted and to see him in prison, is that right?
Sir, I can only answer to my God and my daddy and, of course, to the government and the trial process. So I believe that it may be painful, but there may be times it's necessary. So to that extent, I would say the process needs to be followed. It's painful, but it may need to be followed.
Okay, thank you. I have no further questions.
All right, and thank you, Ms. Griffiths. You may step down.
Thank you, Your Honor.
You're welcome. And if the plaintiff can call their next witness.
Your Honor, we call Joseph Kazmala.
Good afternoon, Your Honor.
Good afternoon, and you may be seated, Mr. Kazmala.
Do I need to be sworn?
Raise your right. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you may be seated. And your witness, Mr. Nisi.
Thank you, Your Honor. Mr. Kosmala, could you please identify yourself for the
Yes,
record?
my name is Joseph Kosmala.
And you're a practicing attorney in the county of Macomb?
That is correct.
Okay, now how long have you been a practicing attorney?
You had to ask that, right?
I'm sorry to admit, I'm impressed by it.
It'll be 49 years in December.
And you've also been an elected official.
I was an elected official. I was a Macomb County Commissioner. I was on the Planning Commission. I was a member of the Fraser School Board for 14 years. I was on one of the boards at Henry Ford Hospital. President of my homeowners association. I've been very involved in public service, yes.
So you're very mindful of the duties that you have to your electorate.
Absolutely.
Could you speak on that a little bit? How do you view your duties and your obligations to the people you represent?
I view it much the same way as I viewed the oath I took when I became a United States Marine. You promise and swear to obey, defend, and protect the Constitution of the United States. And that means being truthful and honest in your actions and doing the best you can to protect the rights of your constituents.
Now, I'm going to try to parse this down into layman's terms, but you will also understand the legal rules and ramifications of that obligation as well. Isn't that correct?
Absolutely. And those ramifications are that, elected official or not, you are held to the same standard as any other citizen.
Now, in terms of a presidential pardon, which is what we're speaking about today, a constitutional grant of authority or power, you're familiar with that provision as well, as read by Ms. Griffiths, correct?
I am. The Constitution provides the president with the absolute right to grant pardons.
Now, historically, the roots of our law in Anglo-Norman law, a pardon was something that was a gift of grace, an act of mercy. Is that correct?
I would agree with that.
A little different now, though, isn't it?
It is.
In American law.
It is.
In fact, a pardon, as noted by Mr. Sedler, is something that requires acceptance of those receiving it. Is that correct?
Requires what, sir?
Acceptance by one receiving it.
Yeah, which is a strange anomaly of terms. Who wouldn't accept it? You know,
Right.
here.
But in fact, one of the important cases in the history of our case law concerns just that. A case where there was an attempt to issue a pardon that was rejected. Isn't that correct?
I believe that's correct.
And you have the case there.
do.
What's it called?
You're referring to United States versus Burdick, which in major part, I believe, stands for the proposition that the acceptance of a pardon is tantamount to an admission of guilt.
Now, the person receiving the pardon in verdict was called before the court to testify and refused to testify, correct?
That's correct.
Now, his basis for refusing to testify was he invoked his Fifth Amendment privilege. He said, if I talk, then I could get in trouble. I could be convicted of a crime. Isn't that correct?
Every citizen has that right.
Yes. So, President Woodrow Wilson issued a pardon to Mr. Burdick, and he did not accept it. Is that correct?
I don't recall specifically what those circumstances were, but I believe you're correct, yes.
Okay. So, with the person in verdict who received the pardon, the refusal to accept the pardon allowed him to continue to invoke his Fifth Amendment privilege.
Also correct.
All right. So, in this case, for example, in verdict case, if he had accepted the pardon, if he had agreed that he would be free from all criminal responsibility, civil responsibility, then there would be no basis for him to invoke the Fifth Amendment privilege. Am I looking at that correctly?
You are.
Okay. So in this case, President Nixon's acceptance of the pardon, though equal to guilt in the argument made by the defense, wouldn't that free him to speak about the same matters that might incriminate him otherwise?
It would.
So if he was allowed to talk about the break-in, who organized it, all of those things, wouldn't he shed some light on what the events were that occurred?
He could have, but you have to remember, we're talking about Richard Nixon, and I think if I may go a little further and perhaps anticipating one of your questions, the problem with Nixon and Burdick, is that Nixon didn't believe it. In an interview, he was pardoned in 1974, September 9th of 1974. In 1977, a mere 3 years later, he had an interview with no less a journalistic luminary than David Frost. In today's market, that would be like going on 60 Minutes, CNN, Fox Radio, whatever. And Fox asked Nixon about his criminal behavior. And Nixon stated, and I quote, "When the President of the United States does it, that makes it not illegal." When the President of the United States does it, that makes it not illegal. Is he not, on that point, refusing to accept responsibility? Is he not at that point saying, I am above the law? I'm the president, therefore what I do, whatever I do, is legal.
Now, I don't want to be disrespectful, but I imagine you were alive during the time of the Watergate.
I was indeed, yes.
Now, and you were also, at that time, were you active in politics or aware of politics?
Not as much as I am today, no. But,
Do you think, given your vast experience in local and political government, or local municipal governments, that the effect of that pardon, of Nixon, if I can use a colloquialism, skating, had an effect on the way business was done as politicians across the country, across the state of Michigan, everywhere?
Oh, it had a very incredibly deleterious effect. President Ford may have felt, out of magnanimity and his friendship with then President Nixon, that he was doing the right thing and perhaps doing the right thing for the country. But it was the wrong decision because it led to incredible abuses of the pardon power by future presidents.
Do you think that that abuses by future presidents, well, do you have any examples of those, for example?
Well, sure. You take the Iran-Contra affair. George H.W. Bush was vice president then. Later on, when Caspar Weinberger came up for trial, 12 days before he was supposed to be tried on perjury charges, President Bush gave him a complete and total pardon. The sole purpose of that was to avoid Weinberger, the facts in the Weinberger case having come to the public eye. That would have been a huge embarrassment to Nixon, or rather to George W. Bush. You've got a former president who has said, without naming names, that if I am indicted, I will pardon myself. Who would have the temerity to say that but for President Ford's prior action?
And do you think that the feeling that those of us who are in political power have an escape route, have an absolute pass, has affected how politicians at different levels of government have behaved?
I believe that's what the final outcome of that pardon decision was. That's where it's led us.
And do you think it's eroded the faith that the country, that the voters, the citizens in this country have in their politicians and their leaders?
Oh, I think we're at a very critical and crucial time in the history of the country right now. Yes, I think people don't know who to believe. They don't know who to trust. And I think they're rightfully fearful that if we do find somebody and we've investigated him and he's committed crimes and misdemeanors against the public trust, he's going to get let off anyway.
So what essentially has happened is we have these leaders in high positions of power who feel that they can get away with anything.
All right, let me go back a little bit. I think one of the reasons Counsel alluded to this in his opening statement, and I know that from time to time President Ford had alluded to it, that Nixon had suffered enough, that he had been publicly embarrassed and humiliated, that he was being forced to leave the highest office in the land. I've been representing people charged with crimes for 49 years. They're not all drug addicts and bad guys that run into stores and stick guns in people's faces. Some of these are good, solid citizens, family men, people with wives and children, people with good jobs who make a mistake. And they are totally publicly embarrassed and humiliated. In many cases, they lose their jobs, they lose their families. But you know what? Prosecutors don't care. They prosecute them anyway. Your public humiliation may be taken into account at a time of sentencing, but that's not a bar to being prosecuted, and it should not have been a bar to prosecuting President Nixon. Look, this man obstructed justice. He lied to Congress. He was involved in a serious criminal conspiracy to commit a felony of breaking and entering, and worse, he lied to the American public. Although anymore, that seems to be a requirement rather than a detriment.
Thank you, Mr.
Thank you, sir.
All right, and Professor Sedler is your witness.
Good afternoon, Dr. Sedler.
Now, you're familiar with Leon Jaworski,
I am.
who was the special prosecutor.
I am, yes.
Now, do you recall, he was the one who would have been filing criminal charges against Nixon.
That is correct.
And do you recall that he said, it would be a mistake to believe that there would have been any new information for the public if Nixon had been tried?
I don't specifically recall him saying that, but I have read of that was his position, and I'm sure if you say it's what he said, that's what he said.
And you, based on your long experience, you are familiar with prosecutorial discretion.
I am.
And that prosecutors sometimes decide that it is not in the public interest to go ahead with the prosecution.
I am equally familiar with prosecutorial indiscretion. But yes, what you state is true. The prosecutor does maintain that discretionary power.
And you have served as a public official. Now, we know that people attack public officials, but based on your experience, would you say that most of the time, public officials try to act in what they believe to be the public interest?
If you're asking, do I think most politicians try to maintain their oath and try to do what's best? What's most? 50%, 60%? But yes, I think
They
there
make
are a
decisions
lot of good and determined and dedicated public servants. Yes, sir, there are.
Regardless of whether you agree with President Ford's decision to pardon Nixon, would you agree that he believed that he was acting in the public interest when he did so?
Do I believe Gerald Ford was? I'm not sure he was acting in the public interest or in Gerald Ford's interest, quite honestly. I think there are there's a long-standing anecdotal situation, since you bring it up, that literally the night after he was sworn in, Alexander Haig approached then President Ford and suggested that there be a pardon, that it would be in everybody's best interest, including Ford's. Ford, I'm told Alexander Haig no, that he wouldn't do that. But then later, anecdotal again, told his press secretary the very next day that he was going to pardon Nixon.
But of course, Ford, as the vice president, would succeed to the presidency.
Of course he would, sure.
And so he had really if he was going to make the decision that it was in the public interest, he knew he was going to be accused of what you've just accused him of.
I presume he knew that, yes.
Also, do you remember John Dean and John Herlichman and Haldeman?
Haldeman, Ehrlich, Mitchell, and Dean.
And Attorney General Mitchell? They were all prosecuted, weren't they, for their cover-up?
They were, along with 49 others. I believe 53 people were indicted altogether, and 44 were convicted.
And so their trial brought out a lot of the evidence relating to the break-in.
I'm sorry, what was that? Their question, please?
They were tried and found guilty.
A
This
large
required
number, yes,
proof
they were.
beyond a reasonable doubt of their culpability in the break-in.
Yes, sir.
Can you think about any specific evidence that might have come out on a trial of Richard Nixon that didn't come out?
Who knows? He was never
Who
tried.
knows? I'll leave it at that. Thank you.
Thank you, Professor Sedler, and you may step down.
Thank you, Your Honor.
Thank you. All right, any other witnesses, Mr. Nisi?
No, Your Honor.
All right. Well, with that note, Professor Sedler, you can call your first witness.
My first witness will be Richard Nixon himself.
All right. Good afternoon, Mr. President. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
So help me God.
All right, you may be seated.
Thank you. Thank you.
All right, Professor Sedler, your witness.
Mr. Nixon, you have been president of the United States, elected for the first time in 1968 and elected again in 1972. Is that correct?
Absolutely true.
Excuse me a second.
While you're doing that, I just want to explain, when you come from the great beyond, you learn certain things. And one of the things I learned is I wanted to change my tie. So I got this nice patriotic tie, and I decided might as well let my beard come out. And so spectacles were necessary. My appearance is a little different than you might have expected. But please ask your next question.
On March 9th, 1974, you made an address to the American public announcing your resignation from the office of President of the United States. What were the reasons why you chose to resign as president?
Well, I'll tell you, that was a very, very difficult decision, of course, because it had never happened before. And mistakes were made. People understood that I had made those mistakes. I was ripping the country apart. I had many, many friends that wanted me to stay on and battle for the position of the presidency and maintain it, but I knew that it was better for the country if I stepped down, that if I didn't do that, that we would be in a situation. Can you imagine a situation where a president would be impeached and have to fight every single day for months and months trying to defend his honor and his actions, as opposed to worrying about the business of the country? And I had established détente with the Soviet Union. I had opened up ties with China. I had done a lot of very good things, and we needed to keep that moving. And if I just consumed the country with what was going on with me, I just ended the Vietnam War. We'd just come out of the civil rights struggles, and to just perpetuate that poison and that toxicity because of me that would be very selfish. I love this country. I decided it was the best thing to do for the country.
On September 8th, 1974, President Ford issued you a full and complete pardon for any crimes you may have committed against the United States as president. You chose to accept the pardon.
Yes, I did.
What were the reasons why you chose to accept the pardon?
It's really the same reason why I resigned. If I didn't accept the pardon and there was a prosecution, it would have been a circus that has never been seen in this world. And our country would have been consumed by a massive distraction. And we've got the Soviet Union with tens of thousands of missiles. We've got the Chinese on the march. And we're going to have our country spend, and I'm a good lawyer. I'm a damn good lawyer, and I would make sure I'd have to defend myself. That wasn't going to be over in 30 days. This was going to take years and years. So the best thing to do for the country. Gerald Ford is an honorable man. And I hear these insinuations that he did it for his own political credit. That's baloney, and I'm being kind. I can use other words. But the reality is, he's an honorable man, and he knew that was the best thing to do for our country. And so, again, it was difficult, because as we've heard about the Supreme Court precedent, which I, of course, was very familiar with, it was an acceptance of responsibility for what I had done. But I understood I had done was wrong. We needed our country to move on.
But you knew that by accepting the pardon, the American public would see this as an admission of guilt, did you not?
Of course.
And since you've left the presidency, what have been your feelings about having had to have left the presidency under a cloud?
Well, of course, it's remarkably difficult and sad to accept. I was in the House of Representatives. I was in the U.S. Senate. I was vice president presidency was really, should have been mine earlier with the JFK was able to sneak in some votes. And then I finally won. And of course, as I said, I accomplished many things. So to have to leave under those circumstances at the apex of my career was extremely difficult. And it's of course haunted me ever since.
Finally, I want to ask you a very, very basic question. If you had to do it over again, would you have made the decision not to resign?
No, of course, if I could relive my life, Watergate never would have happened. But it did, and I would have made the same decision to resign and accept the pardon.
Your witness.
Mr. Nixon?
Mr. Nixon, when the Watergate burglary was discovered, were you so forthcoming about your culpability?
I don't know why that's relevant to what we're here for today. We're not trying me, we're trying Jerry Ford.
I understand. But what I'm asking you is, we're measuring your conduct. We're measuring your conduct because we're measuring the justification for the pardon of your conduct. Now, I understand that your assertion is that it was good for the country. But what I'm asking you is, what did you do? What was your part in this that gave rise to that justification? Because we have to consider it.
I have no idea why that's relevant. I did what I did. Jerry wasn't there. He wasn't part of the White House until he wasn't involved in the Watergate issues. He was in the dark. And so...
But you've testified that a pardon is an admission of guilt. Isn't that correct?
Yes.
All right. Did you ever then, after you were pardoned and faced no criminal culpability or criminal consequence, admit guilt, discuss your participation in the event?
Again, I'm not sure what this has to do with what Jerry Ford did at the time that he pardoned me.
Isn't it true that from the time the incident was discovered, the arrest of the burglars at the Watergate office building, until now, you've continued to proclaim your innocence?
Well, I have accepted the pardon. I have said what I've said on the stand.
All right. Isn't it true that prior to your pardon, you reported to I think Woodward and Bernstein that you pleaded with Senator Griffith, "I'm innocent, I need your help"?
That's what any defendant does. They ask for help.
But you're an attorney and an elected official and owe a great debt and obligation and are here professing your concern for the best interests of the country. So if those things are true...
That's why I resigned, that's right.
Now, you mentioned that as a lawyer, you would have defended yourself. You would have used every
it's my constitutional
resource.
right to defend myself.
That's correct. But if you'd committed the crime, don't you think it would have simply been better for the country that you admitted you had done so and taken the punishment that whatever judge or jury assigned to you?
Young man, that's not how it works.
All right. It's not how it works. It's not how it works in Mr. Nixon's world, or is not how it works for someone who's dedicated to the public?
I'm not understanding why this is relevant whatsoever to what Jerry Ford did.
No further questions, Judge.
All right, and thank you, President Nixon. You can step down.
You're welcome.
All right, and your next witness, Professor Sedler.
Judge John Shimura.
And if you would raise your right hand, do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, and you may be seated.
Thank you.
You're welcome. And your witness was Professor Sedler.
Judge Shimura, how long have you been a judge of the 37th District Court of Michigan?
Professor, I have the distinction of serving for 26 years and am currently the longest serving trial judge in Macomb County.
What is the role of the district court in criminal cases?
All criminal cases start in the district court. The district court treats felony cases differently than misdemeanor cases, so the role of the district court in a felony case is to hear what's called a preliminary examination, which is a hearing before the judge, sort of like a trial, but no jury, just the judge. And the judge's role in the preliminary examination is to determine whether there is probable cause to indicate that a defendant committed the crime with which he or she is charged. If the judge finds that there is probable cause, then the matter goes to the circuit court for a trial or a potential plea. If it's a misdemeanor case that appears in the district court, then the judge hears that case from start to finish, which could include a trial, could include a plea, could be a dismissal, or any other type of outcome.
Based on your long experience as a judge of the 37th District Court, can you explain to the jury the principle of prosecutorial discretion?
Yes, that's a very important principle that the prosecution has. What we mean by prosecutorial discretion is that the prosecuting attorney has a choice to determine whether or not a charge should be brought. Typically, what happens is evidence is presented to the prosecuting attorney as gathered by the police department. And then the prosecuting attorney has a choice as to whether or not a charge should be brought or charges, and what those charges should be. But the important point of prosecutorial discretion is that the prosecutor is never obligated to bring charges, even though there may be evidence to suggest that a person committed a crime. The prosecutor, for any number of different reasons, could always decline to bring a charge if the prosecutor thinks that it simply is not in the public interest, or there are certain extenuating circumstances that would make it unfair or improper for a charge to be brought, again, even though there may be evidence to indicate the crime was committed.
Based on what you have just said, would this indicate that there are circumstances where the prosecutor, convinced that the prosecutor has enough evidence to obtain a conviction beyond a reasonable doubt, nonetheless concludes that it is in the public interest not to go ahead with the prosecution?
Yes, that can happen quite a bit. An example of that might be, I can give you an example of something like that in a case that was in front of me. In this particular case, this person was charged with a triple murder, obviously a felony, 3 felonies, and one of the persons that this person is alleged to have killed was a small child. And there was testimony from a police officer regarding his finding this small child dead. During the preliminary examination, the grandmother of that child was in court and watching the proceedings, and she got up out of her chair and attacked the defendant for killing her grandchild. She was arrested, and she could have been charged with assault and battery and disturbing the peace. But she was not, even though there's overwhelming evidence to indicate that she did do that. And she was not charged because it would not have been in the public interest to charge somebody like that, given the extreme emotional duress that she was under when she had to listen to the testimony of a police officer finding her dead grandchild. So that's an example of prosecutorial discretion and why a charge might not be brought because it wasn't in the public interest.
I'm going to ask you sort of a long question, but based on your experience as a judge of the 37th District Court in Michigan, and based on your knowledge of the principle of prosecutorial discretion, do you have an opinion as to whether it was appropriate for President Ford, in effect, to exercise prosecutorial discretion in prosecuting former President Nixon for any crimes that he may have committed in connection with the Watergate case?
Yes.
And what is that opinion?
My opinion is that President Ford properly exercised prosecutorial discretion by pardoning President Nixon. The reason for that is, well, there are many reasons for that, some of which already have been testified to. I think that putting a former president on trial, and this is regardless of whether or not the president committed the crimes with which he is charged, would have done tremendous damage to the country. Having a president on trial would have sent exactly the wrong message to foreign countries about how our system works. It would have further divided the country, which was already divided, not only because of the Watergate scandal, but because of what was going on in the country at that time. The Vietnam War was just ended 2 years ago, which bitterly divided the country. Other issues were going on at the time. The country was experiencing racial riots, racial discord. Other issues were tearing the country apart at the time. Abortion rights, the counterculture movement was going on at that time, which also divided the country. The country was not in good shape at that time. And dragging the country through perhaps a number of years to endure a trial of a former president would have made things even worse. And so, using prosecutorial discretion, it is my opinion that President Ford did the right thing by not dragging the country through a long trial and making internal matters within the country even worse than they already were.
Thank you, Judge Shamor. Your witness, counsel.
Mr. Nisi?
Your Honor. Pleasure to see you, Judge.
Good to be here. Although I hope I don't make a habit of this. I'd rather be over there.
Judge, you mentioned a specific example in your courtroom, and that specific example was of the grandmother attacking the alleged killer of her grandchild. I forget if it was a female or a male child.
Correct.
But in the case that we're talking about here, when we're trying to apply the concept of prosecutorial discretion to Richard Nixon, who's the victim?
In the case before the court?
Right.
The public.
Excellent. The public. The voters, the citizens of the United States of America, correct?
Correct.
All right. Now, in the case that you had in your courtroom, who are the victim?
The victim would have been the grandmother.
The
And the child, too.
The child. And in fact, the whole family.
The whole family.
All right. So the victim in our case is the public. The victim in your case, in your courtroom, was the child and the family. So by not prosecuting the victim, you've told us that was a good choice. Is that a fair assessment?
Yes.
Okay. So in this case, the one we have before us, Judge Rancilio, we're not trying to protect any victims here, are we?
Yes.
Who's the victims we're trying to protect?
The public, the country.
All right. But who received the discretion behind the prosecutorial discretion?
Well, it's inherent in, well, it would have been Gerald Ford in this case.
All right. So who received that discretion, when you agree with me, would be Mr. Nixon. You exercised prosecutorial discretion not to prosecute Mr. Nixon. Is that right?
Correct.
Okay. So in your case, in your courtroom, would it have been appropriate to exercise prosecutorial discretion not to charge the killer because it would have saved the victims' families stress of going through months of trial? Of course, the alleged murderer is going to try to defend himself in court, hire a lawyer. Would that have been appropriate?
Well, the prosecutorial discretion in the example that I have is not to charge the grandmother.
Right. That's exactly correct. But it would have been inappropriate not to charge the wrongdoer by saying to excuse the wrongdoer from a prosecution because it's going to put the family in pain to put the details of that crime up on the stand, to introduce evidence about the murder of the grandchild. That would have been wrong, though, right?
Well, it would have been wrong because it would have been wrong to put the grandmother through the pain. Well, let me put it this way. It would have been wrong because the grandmother's actions were excused because of the tremendous duress that she was under. And because of those extreme circumstances, it just would have been right to charge her. Right. She was, in a sense, justified in doing what she did, even though she committed a crime.
But you have to agree it's because we're protecting the victim or victims, the family of the slain grandchild, right?
Protecting the grandmother.
Right. But in this case, what you're talking about is to protect the victims from stress or from the emotionalism of the events that occurred, aren't you really just doing the same thing as using prosecutorial discretion to pardon the killer?
Well, you're not pardoning a killer, President Nixon.
Well, Nixon.
Was not charged with killing anybody.
All right, but I'm trying to analogize it to the killer in your courtroom.
Well, you're not pardoning the killer. There was no, you're pardoning, in the example that I gave, the grandmother.
Okay.
That's who's being pardoned in a sense because no charges were brought.
Okay, exactly. You pardon the victim, not the person who created the offense. Now, in this particular case, you're talking about prosecutorial discretion and trying to apply it to Mr. Nixon. In fact, there's no prosecution of Mr. Nixon, is that correct?
Correct.
All right. So who exercised prosecutorial discretion?
President Ford.
President Ford did so without charges, correct?
Without charges, correct.
All right. So do you think that until the charges were brought, until we faced that reality that he might have to undergo a trial or somehow address those, that prosecutorial discretion was justified, that particular concept?
My testimony is that prosecutorial discretion was justified by President Ford.
Before the information came out that gave us a basis to form our decision about discretion?
Well, I think all the information had been brought out. Watergate occurred 2 years previously. There had been numerous testimony given before the Senate committee. Articles had been written about it in the paper. Investigative journalists have been writing many articles, so the information was there.
Did you know at that time, or did we know at that time, exactly what Mr. Nixon had done at the time the pardon was issued? Did we know if he was behind the burglary?
I think we did, pretty much.
Did he ever admit it? Did we have direct proof that Nixon was behind the burglary?
Well, it depends what you mean by direct proof. We had the testimony of John Dean. We had the testimony of G. Gordon Liddy, and people like that who testified as to what happened. And I think by 1974, there was a pretty good understanding as to what happened, even though President Nixon didn't specifically admit to it, but I think the American public knew.
Do you think we knew the full scope and breadth of the corruption that gave rise to those actions and the attempt to cover it up afterwards?
Yes.
Thank you, Your Honor.
All right, you may step down. Thank you, Judge Shimura.
Thank you.
And if you could, Professor Sedler, if you could call your next witness.
Yes, our final witness will be President Gerald Ford himself.
All right. If you could raise your right hand, Mr. President, do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you could be seated, and your witness, Professor Sedler.
Mr. President, you have served as President of the United States upon the resignation of Richard Nixon. On September 8, 1974, you then issued to then President Richard Nixon a full and complete pardon for any crimes he may have committed against the United States as president. This was before he had even been charged with committing any crime.
That's true.
So I'm going to ask you to explain what were the reasons why you'd issued him a pardon at that time.
Thank you, Professor Sedler. I issued the pardon after I consulted with some of the finest legal minds in the administration, had to find out that I actually did have the authority to do this for the good of the country, and frankly, so that I could get some work done. Nixon was occupying almost half of every day. I was very worried about all of the issues facing the country. Inflation was out of control. You may remember the win buttons we had. There was a threat of a new coup in Cyprus. We were worried that the Middle East, the treaty, the Yom Kippur War had been less than a year before. There are all sorts of problems, and I held 2 press conferences, and every question had to do with Nixon and the status of Nixon. And this was very frustrating for me. I, of course, am an attorney. I have a degree from Yale Law School, but other attorneys who I consulted with, and of course, remember, I was in Congress for 25 years, we all estimated it would take from 2 to 6 years for Nixon's case to run its course. And after doing some research, I found we've heard a lot about verdict versus the United States, a case that I still, to the end of my days, I'm carrying a piece of paper in my wallet with a quote from that, as we mentioned, saying the offer of a pardon carries an imputation of guilt. The acceptance of one is an admission of guilt. You don't have to accept a pardon. But also, there's a case at Ex parte Garland in 1866 that established that a president of the United States has a complete right to pardon anybody, whether they've been charged or not. There was a case where some former Confederate officer had been issued a pardon by President Andrew Johnson. It went to the Supreme Court. He said Johnson had the right to do that. And so it was clear to me that it was in the public interest. It was also clear to me that this would likely be politically detrimental to me. But I felt that I needed to do it, and all of my aides told me that. I felt it was something I needed to do.
However, once he resigned, you became president.
That's correct.
Critics have claimed that in issuing the pardon, you had struck a corrupt bargain with Nixon, that the pardon was granted in exchange for Nixon's resignation, which elevated you to the presidency.
I'm glad you asked that. I want to address that question. First of all, there was an error made by an earlier witness that said that Alexander Haig, the chief of staff, came to me the day after and proposed this. He actually came to me on August 1st and told me about the smoking gun tape. This was a tape from June 23rd, 1972, only 4 days after the Watergate break-in. When that tape was released, we saw the transcripts. It was clear Nixon had directed the cover-up from the very beginning, and his administration was going to be over. Haig asked to meet with me by myself, and he talked about a pardon, and he gave me what you might call a pardon kit as to how I could do it. I went back to my office, to my chief of staff, Bob Hartman, longtime chief of staff, justly chewed me out. He said, you cannot give him any implication you would do this, and he made me call him on the phone in the presence of witnesses and says there's no deal, no matter what, for anything. And at that time, granting a pardon was the furthest thing from my mind. But it developed quickly that I could not function properly as president of the United States unless the Nixon matter had gone away. Another thing I want to mention very briefly, there were several witnesses, I believe, who mentioned my longtime friendship with Richard Nixon. We were more associates and, I think, colleagues than presidents. And when I saw that tape, I had spent, remember, as appointed vice president less than a year before any of this, never wanted to be vice president, never wanted to be president. I wanted to be Speaker of the House. And what happened was I went around the country saying that I knew Nixon was innocent, I knew that he had done nothing impeachable, and I read the transcript of this June 23rd tape, and I realized he had lied to me. He had lied to me, and he'd made a fool of me, and I was very angry at him. So I did this. Yes, later on, I did say I had some compassion for him, but I did this for the good of the country. If I may add one more thing quickly, the agreement was negotiated by a young attorney who I'd known for many years named Benton Becker, and he reported he went out to see Nixon in San Clemente. He thought he was mentally not competent. He thought he was in terrible physical shape. He tried to get him to talk. Nixon wanted to talk about the Washington Redskins, not the pardon. And when I came back, and I said to Nixon, you realize this constitutes an admission to guilt? Nixon said, uh-huh. When he came back, he came to see me, and he said, President Ford, it's up to you what you do, but I don't think Nixon is going to be alive at the time of the election if this doesn't end. And I said, well, 1976 is a long time away. He said, I don't mean that. I mean the election in 2 months.
One more point. When you had pardoned Nixon, you had succeeded to the presidency, the vice presidency, when Spiro Agnew resigned.
Right.
How long had you been president before this issue came?
I pardoned Nixon on September 8, 1974. If you'd come to me on September 8, 1973, and suggested I would ever be vice president, let alone president, I would have suggested you see a psychologist. I had no desire. My desire was very clear to me after the 1972 election. I would never be Speaker of the House. And so my plan was to serve one more term and go home and play golf and practice law in Grand Rapids, Michigan. But when Spiro Agnew resigned, and you may remember for utterly unrelated reasons, you know, Spiro Agnew was a crook. He was taking bribes from contractors. They had to get him out of there. And the consensus was that I was the most apt person to be confirmed as vice president. Nixon asked me to become vice president. I reluctantly agreed. I said, well, it'll be a nice way to cap off my career. And then, of course, he resigned.
Thank you, President. Your witness.
Mr. Nisi, cross.
Thank you, Your Honor. Now, Mr. Ford, you mentioned that the agreement was negotiated between a young attorney and Mr. Nixon. Is that correct?
You know, that was a bad choice of words on my part. Benton Becker went out to see Nixon to try to get two things. Well, one was to come to an agreement about custody of the infamous tapes, but he also, quite frankly, wanted an agreement that would indicate as clearly as we could Nixon's acceptance of guilt.
Okay. But still, there was a deal to be made, and the deal to be made was pardon in exchange for?
No, there was no deal. And in fact, our negotiations were sabotaged because I was sabotaged by my chief of staff, Alexander Haig, who I told Becker, now we're going to pardon him no matter what, but do the best you can. Benton Becker then went and called Nixon's press secretary, Ron Ziegler, and so that prevented us from getting the strongest statement we wanted.
With all due respect, sir, I understand there was a lot that happened.
Right.
But
there's no deal. If Nixon had not said one word, I would have pardoned him.
Okay. So your intention was to pardon him without sending the young attorney out to negotiate, whether or not that happened?
I would have, it's like anything else. I was going to pardon him, but if I could get a better deal for the country and for myself, obviously, by getting Nixon to admit guilt, obviously I wanted that.
You're a Republican.
Yes.
Or you were a Republican.
I am a Republican.
Mr. Nixon is a Republican.
Yes.
And you were both part of a committee or Central Republican organization, which was called?
Well, we had a group called the Chowder and Marching Society, which is an informal social club. But we were both members of the Republican Party. Nixon was elected to Congress in 1946. I followed in 1948. And of course we knew each other.
So, you understand we have a two-party system, then at that time at least,
Yes.
and that the big players were the Republicans and the Democrats. And you understand that members of the White House and those connected to your political party were responsible for the invasion of the Democratic National Committee's headquarters, correct?
I don't know that the people who did the break-in, and we have never really established who directly ordered the break-in. We know who did the cover-up. It is, in fact, most historians do not think Nixon ordered the actual break-in. But whether they were Republicans or not, some of them, I believe the Cubans, were not even American citizens.
But we don't know. Isn't that the point?
We don't know. We don't know who ordered the break-in, no.
All right. It could have been Mr. Nixon, correct?
Unlikely.
How do you know?
Unlikely because in other things he said on the tapes, he indicated he could not believe that his staffers, now he knew very well that skullduggery was going on, but he said, how could somebody order something this stupid? And he seemed to be sincere.
Okay. But the point is, he never spoke on it in such a direct manner that you could make a judgment about his testimony. Isn't that correct?
Well, I think the issue is not the break-in. The issue is the cover-up. The cover-up was the major crime involved, and he did certainly essentially admit to that. And as Becker told me, he admitted essentially to obstruction of justice.
Well, isn't the point not the cover-up or the break-in so much as it is the method in which we elect our officials? I mean, we have a two-party system, sir.
Right.
Two-party system, correct?
Right.
And one party took illegal actions to try to thwart or damage the potential for those who voted for Democrats to have elected officials that they preferred. Isn't that the real issue?
I think you're making an error to say that all Republicans are alike. At the same time, in the Democratic Party in Congress, you had Elizabeth Holtzman, the very liberal representative from New York, and you had people like Stennis and Eastland, racist segregationists from Mississippi, all were Democrats.
Isn't the real issue here the effect to thwart the democratic process by obtaining information through illegal means from the opposing side, from an opposing party? Isn't that what we're really all talking about here?
Well, that is why Richard Nixon had to resign the presidency, because he did attempt to do that, or his minions attempted to do it. He attempted to cover up, and so...
But he could have resigned without a pardon, couldn't he?
He did resign without a pardon.
All right. And he could have, if in face of the articles of impeachment, simply agreed that they were correct. Isn't that correct?
Well,
you're a lawyer, Mr. Ford. You know that if you're presented with articles of impeachment, you may concede and say, yes, I should be impeached.
Well, being impeached is not the same as being convicted.
I understand.
Think we've
I'll get to
overlooked
that for the next question.
And let me say something that, really, just let me mention one other brief point. Had Richard Nixon been convicted, he would have lost his pensions, he would have lost his Secret Service protection, and that may have been a factor. But he had been effectively punished. We've not mentioned the IRS moved against him. He lost all his money, lost all his prestige, and there was no possibility that he could run for another office, certainly not the presidency.
Okay, so you think that the punishment he received for trying to thwart the democratic process was adequate?
I think I cannot imagine any greater punishment for a public man, let alone someone who had wanted to be president all his life, to be humiliated, to be the only man in history to have to resign the presidency. I think that Richard Nixon was punished more than he could ever imagine have been punished, and to have been sentenced to 5 years in prison at some point for some minor obstruction of justice would have been nothing compared to what he suffered.
So you understand that people might have a difference of opinion as to whether that is an adequate punishment for trying to undermine the entire democratic system upon which this country is based?
Of course, that our country is based on political differences, but I also understand that had this country been convulsed and tied up in Watergate for another 2 to 6 years, important world and national business would have gone neglected. And I could not do that on my watch, even if it meant that I would lose the presidency in 2 years. At that point, I hadn't even decided whether I'd run again.
Wouldn't have been very good for the Republican Party either, would it?
I think it might have been worse for the Republican Party had I not pardoned him.
Thank you.
All right, thank you, Mr. President. You can step down.
Thank you.
Any other witnesses on behalf of the defense, Professor Sedler?
Members of the jury, it's been a long afternoon. You've had to sit through all the testimony, and now you have to sit through the closing arguments. But the jury is such an important part of the American constitutional system. We are asking you, as representatives of the community, to decide one basic question. Was President Ford justified in pardoning Richard Nixon? Now, it's very clear that with the pardon, there was an admission of guilt. And you heard Nixon admit that and explain why he admitted his guilt. That's his version of it. But the point is that he did admit his guilt. But more importantly, he was removed from office. He was no longer fit to serve as the President of the United States. And he was removed from office in one fell swoop. As President Ford testified, had Nixon not resigned, there would have been a long trial. There would have been appeals. And in the meantime, Nixon would have continued as President of the United States. The most significant thing about President Ford's removal of Nixon, that's exactly what it was, Nixon's resignation in exchange for the pardon, is that Nixon was no longer the president. You know, under our Constitution, the entire executive power of the United States is vested in the president. Cabinet members advise, but unlike in a parliamentary system, they have no control. Do you think it would have been in the public interest to see Nixon continue as president, to deal with all the problems in the United States and the world in the early 1970s while under a cloud, the first item of news every day would be not what was happening in the United States, not what was happening in the world, but what was happening in the trial of Richard Nixon. The prosecution has really not given any good reasons. They've said, well, he violated the law and he should be held to be account. But as their own witness admits, and as our witnesses, especially Judge Chamorro, testified so graphically, the notion of prosecutorial discretion is so much a part of the American system. Victims of crime cannot control the prosecution. Only the prosecutor can decide whether to proceed with a prosecution. It's interesting that the special Watergate prosecutor, Leon Jaworski, said there was no more evidence that could have been brought out. The whole story of Watergate had been laid before the public. The pardon of Nixon was in the public interest. And this is where we end as we begin. And I ask you to consider not whether if you were president, you would have pardoned Nixon. You might not have. Did the prosecution give you any good reasons to prosecute him to continue enmeshing the nation in Watergate, Watergate, Watergate? I submit that based on the evidence that has been presented to you today, you should properly conclude that President Ford was justified in pardoning Nixon in exchange for his resignation from the presidency. It was a time to heal, a time to build up, a time to move on. Thank you.
Thank you, Professor Sedler. And Mr. Nacey?
Thank you.
Closing arguments?
Thank you, Judge. The reason, to answer Professor Sedler's question directly, that Mr. Nixon needed to be impeached and perhaps prosecuted is because we are his victims. In this country, we establish a rule of law and we decide who judges cases or makes laws or enforces laws, largely by voting. We decide together who's going to make the decisions for us and who's going to lead us. The crime committed by Mr. Nixon and the political party he was affiliated with, at least the individuals involved, and we can't say that they're all bad, all Republicans, but at that time, the Republicans involved, was trying to take that system where we all determine our own free will, make our own decisions, and have the freedoms that we all appreciate. They attempted to take it from us and make this country into something that it was not intended to be. And miraculously, instead of fully agreeing and disclosing the fact that that's what they were after, to affect our right to vote and make our own decisions, they've taken the same ridiculous attitude that, oh, you know, it's not good for you. We're going to try to protect you from us. It's like the example in Judge Chamorro's courtroom, the grandmother who was attacked the killer, and I'm sure the little grandmother didn't have much of a chance of really hurting the killer, just like all of us don't really have much of a chance of affecting a president in our normal lives. But that grandmother who attacked the killer, what Judge Chamorro is really saying by saying we should pardon Nixon, or Gerald Ford is saying by saying we should really pardon Nixon, is it's so damaging for us to go through the trial and see our rights be deprived and see our loved one die, that why don't we just pardon the person who committed the crime? Because if we pardon the person that committed the crime, we don't have to try the case, we don't have to relive the murder, we don't have to relive what is frankly a form of treason. You know, you hear a lot about prosecutorial discretion. That's how they describe what Mr. Ford did. But that's really not what he did. What they knew is that once an impeachment happened, and no one was talking about prosecuting him criminally then, they were talking about impeachment. Once the impeachment happened, you heard Martha read the law, read that portion of the Constitution. I'm Gerald Ford, I'm the president. I can pardon anything, except one example, impeachment. Because once that happens, the facts are established, the truth is known, and you can't go back on it. You can't erase it with a piece of paper or a pardon kit, as was described by Mr. Ford. Then it's done. So what they did was cleverly, before any charges were brought, remove the criminal charge with the pardon so there could be no impeachment. And there could be no full disclosure of all that had happened and all the transgressions that were taken against us, that we were the victim of. And again, why? And the reason why is, because it might hurt our feelings. Because we were going through so much upheaval that we might be hurt if we knew what they did. Now, I have two things to say about that. First, it's not true. The American public, we're not children. We're adult, responsible, free, proud people. And two is, even if it did hurt, that's our responsibility as citizens, to face that, to understand what the truth is and take appropriate action that we as a people decide to address, not because Jerry Ford thinks it's a good idea that we don't have to deal with it, or because Mr. Nixon thinks he's doing us a favor by getting off scot-free, by walking away from humiliation. And I don't care if he's a public man, and I don't think you should either. Being embarrassed because you've done something like that to the American public doesn't mean you've suffered enough because you got caught. So what I'm suggesting to you all is that our obligation, when our way of life is threatened, is to find out what happened and appropriately address it through the mechanisms afforded to us through the Constitution and our state and local laws, whether it be impeachment or criminal prosecution. In fact, I would suggest that there's nothing more important than to follow that process when our right to vote is compromised by Tricky Dick. So what I would like you to do when you get your jury form, I think you already have it, is say, no, Mr. Ford wasn't justified in taking that decision away from us. We should have made that decision as a people. We don't need to be taken care of by Gerald Ford, Richard Nixon, or any of their motley assortment of characters who broke into the Democratic headquarters and put listening devices and stole documents. Thank you for your time.
All right, and this matter has concluded, and I will now submit this case to the jury, and you can mark up your jury verdict forms and indicate what your opinion is. All right, everybody, so the jury foreman has just handed me the verdict form where the votes were counted, and it is now, after reading it, 19 juror members found that the pardon was not justified, and 18 found that it was justified. So the verdict, is in favor of the plaintiff. Thank you, Mr. Nisi.
I interviewed President Ford in 1995 at his home in Rancho Mirage, California.
Okay, and by 1995, did he have any regret 20 years after the fact of his decision making?
He had absolutely no regret about the pardon. It was clear to me, what sort of startled me was, that he had not much good to say about Nixon. And he had some regrets about what he did as president, but not really about the pardon, not at all. I asked him, if you knew you would lose the election, would you do it over? He said, probably.